We'll convene our special municipal council meeting on Wednesday, July 29th, and call this meeting to order and acknowledge that we are in Mi'kma'ki, the ancestral territory of the Mi'kmaq people, and we are privileged to share the land with them. Would someone move the approval of the agenda? Moved by Councillor Burns, seconded by Councillor Bell. All those in favor signify by raising their hands. Motion is carried unanimously. We have the main purpose of the meeting this evening is to repeal and replace municipal planning strategy and land use bylaws. We have concluded our special hearing, and we will turn it to staff for a presentation, and I don't know whether there's another presentation or what we do at this point. Do you want to make any comments?
Yeah, I can make a comment.
Mr. Merrill?
Now that the public hearing is closed, council can consider the written submissions and the verbal presentations that were made this evening, and council can either approve or refuse to conduct second reading. And I believe there's a draft motion.
So at this point, we will open it for discussion, and I do want to maybe begin that discussion by just saying that we have had public input tonight, and we've heard from a number of residents. So the discussion this evening will be, I think, and we've had a lot of discussion, folks. We know that. But there were issues raised tonight that we may want to consider, and that will be what you, I hope, are going to bring forward in the discussion. How you feel the balance is between what we've heard in the more recent presentations, the last ones we've gotten around agricultural land. We've heard from people tonight regarding development, and those development discussions would have also been part of, I think, the coastal protection discussion. It's for those that were here for that. But we have heard a variety of issues that were raised tonight. So now is the time for council to consider that and to weigh in on our next steps here. So I open the floor for comment. Councillor Bell.
It's a question through you to the Planning Committee on process at this time. Hearing a discussion with regards to existing lots that have an engineering diagram or a surveyor's diagram on a proposed land development as per a individual lot, or a property that is partially developed having a septic system put in, or a well, or both. And I know a number of people who have done that. I was a person who put my well in a year ahead so I could pay for it before I went to get my septic system, which I put in year 2 and built my house in year 3. So I'm probably believing that there are still individuals that do that process that don't want a hefty mortgage. So is there a way that a provision could be put in for existing lots that are fully developed within a 2-year period? Meaning that they have any of the 3 things I mentioned. A property that's partially developed with what would make living space, so a septic or a well or both, or can give proof of where an engineering diagram was prepared for that lot, but it doesn't contain a building yet. Is there a way we can put a provision in to capture that group without opening the floodgates? So they would have 6 months to come in and register the property and show the proof, but that doesn't mean that is done in that 6-month period. It has to be done prior to this date. Is there a way we can accommodate that group of people? And it doesn't matter to me whether it's a contractor or an individual. A piece of land that's being developed is a piece of land, regardless of someone's income or status of whether they're a company or an individual.
I think the planners are having a little huddle over that question, because it could be broadened to, I guess what you're trying to address, Councillor Bell, is how we can build in the exceptions. And we do have exceptions. I see them going now, no, but I'll leave it to them to comment.
Thank you, Mayor. I will answer, and if Jeff will consider that there's more to add in, then he can do that. In terms of adding anything in right now, one means that this will be a substantial change to the document, so meaning there will be an end to the first reading. Council will have to stop the clock on first reading and send us back to do revisions to this document. There's always an option for amendment process. It's not the first time. So having a septic and a well being built in before, and then a property owner comes to us and asks to develop, in most situations, they can do it. The reasoning also for the undersized provision that we add, undersized lots provisions that we inserted in, is to ensure that smaller lots that might not meet watercourse setbacks will be developable. However, if a lot, for example, has certain grade in it and the topography changes, we didn't take that into consideration when we provide that exemption in, because it was really a question of, can a well, a septic, and a house be fitted in the property, even if it will not meet the setback requirement. That's what we were looking at in terms of that provision. In most scenarios, with how the documents are written, we planning staff made sure that most lots are developable. Some might need more work than others, but in most cases, they are developable. To your question, it's either that the property owner will ask for a rezoning or an amendment if council approves this. If council passes second reading tonight, or council decides not to pass second reading tonight, stop the clock on the first reading and send planning staff to make more revisions and come back with draft number 5.
Just to add to that, council will recall that we built in exemptions in the cluster development land use bylaw that they were not in the original draft, but in response to presentations from property owners and developers, we came up with an exemption for both cluster development land use that involve phased development condominiums, and then we added another exemption because we had additional presentations by developers who were not doing phased development condominiums, but were partially underway. So council has, in the past, taken into consideration certain circumstances that would allow for exemptions. They put a time limit on them so that there was an onus on the property owner to move things forward. So if council is inclined, draft 5, if it's required, could look at that. We would have to have discussions with council on what kind of exemptions would you like to consider and what factors would you like staff to look at, and likely make it on a property per property basis. So we could incorporate those if council was inclined to direct us in that fashion.
Councillor Smith.
I would like to speak to the changes that were made from draft 3 to 4. concerning agricultural lands. And from the outset, I want to say, you know, as council, we were very, very responsive from when draft one, you know, landed, to remove some things around animal counts and things that restricted farming, that people were very grateful that we were responsive about. And I know that, and I've really enjoyed the conversations around the table about agriculture, and I think we've made some changes toward the end that have undermined our policy goals around agriculture, protection of agricultural lands. And I just want to say, you know, like, there's a lot of farming in my area, and I spoke to, between the drafts since the first reading, I've spoken to a lot of farmers, different kinds of farmers, market garden, farmers market farmers, livestock farmers, farmer with, who works on a very large farming operation, and a couple farmers who would be considered hobby farmers, but multi-generational, and bring in some money with their farm. And when we moved from the zone to the overlay, and decided that we were only going to protect the active parts of farms, it meant that suddenly we were applying the overlay to many small parcels of land. And it only came to light during the first reading just how small those parcels of land were. So the bulk of the lands, over 70% of the lands, 656 parcels of the 888 parcels are less than 5 acres. And our policy is to protect those from fragmentation by only allowing 6 subdivisions. That really doesn't provide any meaningful minimization of the fragmentation of agricultural lands, which our policy states we're trying to do. So there's this disconnect between our stated policy and the overlay. And something that came up in some of the written submissions, which I think is very pertinent, is that when somehow how we've defined and identified active parts of farms, it doesn't reflect the multi-use pattern of farming in Lunenburg County. So for example, Christmas trees are not counted. Christmas tree lots are not counted. So if they're on the same property and you've got one farming use and then you've got Christmas trees, they're cut off and they're not included in that protected area. That doesn't make sense because the way people make money on farming in Lunenburg County is through various means. They patch things together. And I heard that from many farmers in my area. And the other point that was raised, I thought quite well by Mr. Drysdale from the PAC committee, from the Planning Advisory Committee in the written submissions, was that we have moved totally away from protecting lands with agriculture potential. So we're only protecting these very small, narrowly defined active parts of properties. And the provincial statement of interest on agriculture explicitly says that we need to address lands with agricultural potential. And I know that we don't like to, stick too closely to what the province mandates. And, we're trying to find our own way on this plan. But I just would note that the mandatory planning and the statement of provincial interest on agriculture was hard-won by stakeholders in farming. So when that bill was passed, the Nova Scotia Federation of Agriculture was very pleased and put out a statement to that effect. So it's not just the province that wants us to do this, to protect these lands from disappearing. It's also coming from farming stakeholders at a higher level. So to me, like I have to think like what would be acceptable for me to vote for this bylaw in terms of agricultural protection. And number one, the number of subdivisions needs to line up with the property size. So if we've got like most of the properties in that zone are under 5 acres, we should not be allowing 6 subdivisions on each of those properties. We need to think about how many subdivisions actually minimizes fragmentation. And the second thing is that if there is an active farm identified for that zone, the whole property should be protected. And this reflects my conversation with farmers and reflects a lot that I heard during the land use planning process. And I think that it's a compromise and is more of a balance between the competing priorities that we've seen over the course of this process. Thank you.
Councillor Hubley.
I think we're always going to be midstream, no matter when we do this. The document, it's a living document. It's not perfect. I do have a question. If the reading is passed tonight, and we take into consideration Mr. O'Leary and Mark, I didn't catch his last name, they have a property that could possibly not be developed. Can they come to council to get an exemption on a single parcel so that they could develop it? Is that something that they can do? I don't want to render any property not developable.
I can't answer that, but somebody, I'm sure someone can, and this is a very similar conversation, I think, that you would have probably struggled with coastal protection. Yeah.
Thank you, Mayor. Yes, they can come to council and request an amendment process. And we can be assessing either all properties around within that watershed area or their specific property.
Thank you.
Councillor Moore.
Thank you. I heard a lot of good conversation tonight that I wish we would have heard a year and a half ago, but that's okay. Nothing like the 11th hour. But I do have concerns, the same as Councillor Hubley does, that some of these properties, once we pass this tonight, if it passes or whatever, are going to be rendered worthless. And I'm getting back to the lady that has her well and her septic. Can she come, if this passes tonight, can she come and get an exemption so that she can continue down the road to build her house?
We don't really know what, it's most likely that the property is developable. Bayport, by the way, is already zoned in the Riverport and District area since 2009. So if she's talking at the property from the community she's located, well before 2009. So that area already had zoning, and most likely she can develop that area. She just maybe was waiting, or we're not assessing why she didn't develop, but there could be multiple reasons why she hasn't developed until now. That area already had land use regulations, and she most likely can't develop. I can't speak directly because I don't know the specific parcel. In regards to Mr. O'Leary, I know exactly which parcel it is because we have been in discussions. It is developable, is lot. It's just there's a bit more work that needs to be done. It's not deemed undevelopable.
But my question is, this lady I'm looking at specific comments tonight. This lady, if she wants to, she can come to council if this passes tonight and explain to me what the zoning in Bayport is different than what that would mean. I mean, can she develop it now with the zoning that's there?
Again, most likely, yes. There's two zones in Riverport and District area. There's a rural zone, and so it's called the RU3, that you're allowed to build up to 4 residential units as of right, and other permitted uses, of course, but I'm talking about residential right now. And there's the environmentally sensitive zone that applies to where wetlands are located. But if she has a septic and a well, it means that there's some area there to also build a house if that's what she wants. So she doesn't really need to go to council, she just needs to meet with planning staff and a development officer with submitting development permits because the regulations are already in place. It has nothing to do with the discussion here tonight.
Oh, okay. That makes me feel better because I misunderstood that.
Councillor Oikel.
One of the things regarding the agricultural land that I'm really like, even though I did read all the letters, is that the land that is farmed but not part of the agricultural overlay can be added. People can add on to it if they want and they feel that more of their property or their property that isn't even part of the overlay can be added. So it can be enlarged and it can become bigger. It doesn't have to be just what it is. And that's what I really like about it. So that people who want it, it gives them the freedom. They own the land, they can decide. And I think that's a wonderful thing.
Councillor Reinhardt.
I have a question about the agricultural land policy, because you mentioned Kings County, and that they have dropped the requirement to get a soil analysis to remove their property. So I was just wondering if you know, do they still have an option to remove the property or with a different process, or do they just have no option and the properties are just in that zone?
Okay. To our knowledge, they removed that policy because it just didn't make sense. Kings County also has Class 2 soils, so it's a bit more way more fertile land than what we have in our municipality. To my knowledge, they did not add a different policy to remove it. But I might be able to give you a different answer in a few minutes.
Deputy Mayor Vino.
Trying to think of the right words to say to this. My brain's going back and forth on the lot sizes. If a lot is not big enough, then we can lower that restriction down to 70 meters. If a developer or an individual buys a large piece of land and they divide it in lots to sell, if situations like tonight where they may have broke down those lots based on rules that didn't exist, if it limits what they can do now, that's when they can come in and ask for an exemption. Do we think that there's a lot of cases out there right now where we have potential developers who have subdivided a piece of land and might face similar circumstances of lots being unsellable?
Planning staff have not received phone calls or any comments of that sort. The reason with the rationale for the undersized lots, first of all, comes from also Queens, region of Queens have that type of policy in, and we want to embed that policy to enable lots to be developed, even though they are waterfront lots that might just be too small to meet the 20 or 30 meter setbacks. So again, it doesn't mean that they're immediately going into a 7-meter setback. We're going to assess it might be 25, might be 20, might be 18. It really depends on how much can we go further back from the water as we can while still developing something that is feasible and viable for the property owner.
Just want to comment. Looking at adopting a system that encourages individual property owners to come to council and request an amendment to the municipal planning strategy or land use bylaw is not a strategy we should be endorsing. If council is interested in making some kind of exemption, it would be much preferable, at least from my position, to send us back to look at that and come with more information. As I understand from Mr. O'Leary and Mr. Hoadley, they intentionally designed lots that are 40 meters deep along a lake because 40 meters seems like, or would have seemed like, a lot of property to develop along the lake. And they did it at a time, likely, when there was no zoning. And now we're looking at a setback of 30 meters to a 40-meter lot, which pushes everything back to the road. And whether council wants to make exemptions for those kind of circumstances, I think that should be the focus of the discussion, and not whether we want, a lineup of individual property owners approaching council on a regular basis to amend a bylaw that we haven't even adopted yet. The process is going to be incredibly staff intensive, and council would likely be inundated with individual applications. I think it's much better to consider whether we want to look at exemptions on a property per property basis and have staff come back with what that might look like, if that's something council wants to consider. I don't encourage you to adopt this bylaw and state publicly that we'll just entertain amendments one after another, because that just doesn't make a lot of sense. If the issue is of that significance to council, then we shouldn't be rushing forward. We've taken a lot of time to do this. I hate to say this, but a little more time isn't likely going to make a huge difference. And I'm trying not to look at the planners because they're probably,
They're going to hang you.
apologies, but I think that if the points hit home, then that's something we should consider. If the point hasn't hit home in the sense that the setback is what's important, then we can proceed. But I think that's where council has to have the discussion. Is it the setback that's important? And if so, maybe we shouldn't do any exemptions. But if the interest is housing, developing lots that currently exist, so clearly if the lots don't exist, there wouldn't be an exemption. You can design new lots to take that into account. But for those lots that have been developed by private developers on private roads that have not yet got houses on them, because if they have a building permit, they can act on the building permit. That's a non-conforming use. They can build as if the land use bylaw didn't change. But in those cases where people are holding property for future development on lakefront, which is some of the most valuable property that we have in the municipality, if council believes that we should take another look at that, then I would encourage council to send us back to look at that and come up with and work with developers to try to get something that makes sense and is workable for those circumstances. And I just can't believe I'm saying that.
Councillor Burns and then DeLong.
Thank you. 2 points here, one on farmland and one on overall winners versus losers, because that's going to happen. I want to reiterate my point. We sit at the nexus of balancing what we are deciding as a council is the public good through the lens of what the province is telling us is the public good, specifically through 5 provincial interests and individual rights and what people have been doing with their land and what they intend to do with their land. Because we sit at that intersection, there is no path, nor is there any time we will choose a path at which there will not be winners and losers. This will happen, and when we have this conversation in a month, based on how I think this is about to go, we are going to have the same conversation about a new set of winners and losers, because a new set of people will come forward and they are going to bring concerns, and this is going to change over the years. With all due respect to everyone, we've been going through this now for a year and a half. It has taken the absolute energy of council on almost everything, and the things that people have come to council to do other than this, all are sidelined because we're doing this. If I had the kind of money that was going into developments, I would have been here before tonight. I also respect what they're bringing to the table, and it is a concern, and I suspect that council is going to send it back. In a month, or 2 months because of the summer break, we are going to have this conversation again on a separate issue. So at some point, we are going to have to pull off the Band-Aid. When it comes to farmland, before I move on that point, I also want to remind folks that several months ago, we spent an entire day workshopping this in a public forum. And we talked about the importance of the setbacks and what we thought was the public good and why we had these setbacks. And I was in the minority of people in, in choosing the smaller setback. And I've very much respected that as a council, we decided on a slightly larger setback than what I would have gone with. I think we should keep in mind that at that point, everyone said that was the good idea and that was worth forging forward. So we should also consider if that's still the case, because as we're designing lots here, just think about this. We're kind of moving targets a little bit on this, is how I feel. We've decided this 6 or 8 months ago on what we thought the setbacks should be. When it comes to farmland, I'm really glad that we've made the change in this. That's why I voted against the last draft. It's why tonight I came prepared to vote for this. I've had a lot of conversations with a lot of folks in my district, a lot of people who misunderstood what we're doing, people who initially came to me and said, why are you not protecting lands? And I explained that based on the data that we had and what we could come up with, I thought that it was the wrong way that we were protecting lands. And most people agreed with that. And most people have said we want agricultural lands to be protected. An incredible amount of people have told me, I want to see it happen and don't tell me to do it, is the paraphrase of what I've said. So I like that there's voluntary options. I hope to see a lot more voluntary options, and I hope to see a lot more agricultural land protected. I have faith that people are going to bring their lands forward. People have stewarded the land for generations. I have faith that they want to continue to see it used that way. And that's my comments.
Councillor DeLong.
I'm really trying to choose my language here. There's a really fine distinction between changing one's mind and flip-flopping. And the changes between draft 3 and draft 4, I don't necessarily agree with. And I think that at a certain point, we are just going to have to say that this is the draft that we have, and we need to be willing to make changes to it in order to benefit our residents. Like, we need to be able to pass this and move on and then make it better. It is a living document. It's not going to stand as it is in perpetuity. I agree with what Councillor Smith said about diversified farming and how it's the only way to actually make a go of farming is to have, you know, a certain amount of head of cattle, a certain amount of acreage of Christmas trees, some garden, some market garden. I don't think that we've approached farming in a way that actually reflects how farming is done. And if we're protecting farming, I think it should be the whole property, because you can't protect the field without also protecting the infrastructure of the house that the farmer lives in, the barn that the tractor lives in, all of the things. I also do think that there should be a process for exemptions, particularly for land that has, you know, already has a design in place, or work that's commenced or what have you. I understand that there are certain mechanisms by which certain properties are grandfathered, but at some point, we have to vote on this and say, yes, this is the version, and then move ahead with amendments after that.
Councillor Reinhardt.
Yeah, I'd just like to speak to the agricultural piece one more time, because we did receive some written submissions on it. And for me, we started with a policy that identified about 15% of the municipality. And then when we moved to the agricultural protection area, that dropped to about half of 1% of the municipality. So that's just such a significant change. And I don't have a lot of information on how that will affect the overall agricultural nature and system of our municipality. It also, doesn't take into account a lot of the feedback we received on how important it was to identify potential agricultural land in our first round of public consultation. So I'm just, I'm concerned that we haven't found the right balance between what we had in draft 3 and what we have now. So that's kind of what I have to say about the agricultural piece. And I'll just add that we also, we spent a day workshopping that policy as well. And then it was changed. So, I'd just like that to be considered as well.
Just to Councillor Reinhardt's earlier question, so we were looking at the King's municipal planning strategy, and it seems that the only way to remove lands from the agricultural zone in King's is to amend the strategy as a whole. So it wouldn't be through a road zoning, you would have to amend the strategy as a whole.
Which is a much bigger process.
Correct.
Yep. Councillor Oikle? Councillor Hubley? No? Okay. Councillor Burns?
As a third point, I'd also like to strongly suggest against any path that would facilitate individuals coming forward for specific exemptions if there is a valid argument at the table tonight about general exemptions that need to be made. But if we move forward on a path in which individuals come forward with the strategy to make individual variances, and it both defeats the purpose of bringing it forward in the first place, but second, the only people making money off that are the litigators and the lawyers and everyone else involved in this, and it's going to chew up staff time. It's just going to lead to decisions that are consistently challengeable. So I'd suggest if there are folks who are uncomfortable tonight with what has been brought forward about lots that are subdivided as they exist, then that would be a conversation about a general exemption about those. I would not encourage anyone to rely on individual exemptions for that.
Councillor Bell?
It's been a long process, and I don't have any appetite in starting back at step 1. I would rather, after 36,000 engaged visits and 28 in-person open houses, at least 14 that I attended, I would rather pass this as it is, knowing that it's not perfect. And then if there are certain areas that we need to visit afterwards, we have the option to do that without making any promises tonight. And so if the motion comes to the floor, I'll be voting for it.
I'll put the motion on the floor if it needs to be at this time.
I want to
Okay.
make sure that people have had time to think. I do want to just address personally, the farmland question. there's only 15% of the land in our district that's actually Class 3. And of the 15%, 64% of that is forestry. So when you start doing the numbers on it, it turns out that the actual land that is in active or could be, that's cleared land that could be used, is a very small amount of the land. So I think we need to put this in the right context, particularly because it's Class 3. And having picked tons of rocks on these fields in Lunenburg County, this is not an easy place to farm. And there are many who sit around this, a number who sit around this table who know that too. None of the documents that we're using, whether we want to discuss the soil, Canadian soil maps class and their designation on Class 3, or defining what are active farms here, that's a kind of a nebulous term too, how that is defined, because some might say it's, are you registered as a registered farm within Nova Scotia with the provincial government? And there are many who farm here that are not registered farmers. So how we define that active farm is somewhat arbitrary, even though that information came from the Department of Agriculture. So I get that we question how accurate that is. But the reality is here that the parcels of land, because I know there's some reference to only 4 farms over 50 acres. Like, we ran a commercial farm on 3 farms of 80 acres. So, you know, that's what the land is like here. It's drumlin surrounded by a stream of water and a wetland usually, and you can go through the whole district and find those drumlins, particularly in the northern part and the area, Cornwall area, particularly, where we've defined some of that area as farmland. So we do have a weird, and I'm going to say it's a weird place to farm. A long history of it, mostly because people here, they fished, they had a garden, and then they did forestry work. That's the history and I think Ms. Gibson outlined it well in defining it as she outlined in her presentation. But the idea that we're going to clear forest land here and make fields is not, that is not, I think, very realistic. So defining, as we did before, that agricultural land would be defined, we would use that Class 3 soil without any other lens over it to define what was farmland, was very misleading. Is what we're defining now the best? I'm not sure it is, but I think it is more accurate than just the wide sweeping defining Class 3 and having that as protected land, because I think we did hear from people who said, you're not going to clear that land. You're going to clear that land and find granite rock. And those boulders are there waiting for you to take the trees down. So I think in our discussion, it's important to put what is reasonable here to define as farmland. And when you take that Class 3 soil and overlay it with what we can safely say are active farms, we have a much more accurate picture of what's reasonable here to farm. It's not perfect, and I get the mixed farming, because that is the history here, except if you're a chicken farmer or that's really the only ones that are specialized in one particular area, but most of them are mixed farms. But I think we've done a pretty good job here of mixing those two filters together in a way that is more accurate on agricultural farmland. And the second point I want to make is around the exceptions. I agree with that. It's been raised by the two who are legal beagles at our table, our two lawyers who sit here, but I think it would be wrong for us to go down a road where we allowed a lot of amendments to come forward. We're going to be bogged down as a council with individual requests for changes that I think wouldn't be in the community's best interest. Because that's what we have to think about, is the broad community, and I think Councillor Burns has spoken of this, the public good, which is what we're trying to do here, planning for growth and development in our community. And yes, we know people don't want to have new rules added, but we are seeing growth, and we want to make sure we have growth in the right places. So if, as a council, we feel that we need to take time, again, on another area which has come up, we've taken lots of time. And I think, honestly, we're going to have one of the better planning strategies in the province because we've taken a lot of time to do this. And as difficult as it has been by times, and as tired as, honestly, as we are of the conversation, taking time isn't a bad thing. And if there's willingness or an appetite around the table to do that, we will do that, and consider what some of the issues are that could be reasonable in thinking about exceptions. I think it would be wrong just to do it based on what we heard tonight, because there are likely another long list of things that should be part of that conversation. But it opens up the conversation to say, is this something as a council we want to entertain now? Or, as Councillor Bell said, do we want to go with the document we have and then entertain amendment? Am I right in saying amendments?
Yes, there could be an amendment
Yes.
in the future to add an exemption
Right.
in the future if that's where we
Right.
want to do.
So that's what I think we're down to in terms of strategy tonight. So is there anyone else that wants to speak? Otherwise, I'll let Councillor Oikel put the motion on the floor. Councillor Smith.
I just want to address agricultural lands one more time and just say, voluntary is great. I spoke to a couple tonight who, when they heard that they could add their lands to that zone, they said, they wanted my phone number, we're going to talk about it. It's great. But it isn't just about the choice of landowners who own land today. It's the choice of people in the future. It's about the next generations and about the land being there. And I will just say, on the fragmentation piece, that policy doesn't work. Saying that we're limiting fragmentation when most of the properties are under 5 acres, I would just really like it if we could look at that data and just see if we could tweak it. If we're going back to amend some other, to look at some other exceptions, I would just ask that we have a chance to deliberate on that one piece of the agricultural protection area, because the number of subdivisions, the math just isn't right for me. And I think it could be tweaked and it wouldn't have an overblown impact on people. So I'll leave it there.
Anything further anyone wants to add? Okay. Councillor Oikel, do you want to put the motion on the floor?
Certainly. To Mayor McLean-Weil and members of council, I move that municipal council conduct second reading and repeal the existing municipal planning strategy bylaw 035 and the municipal-wide land use bylaw 049, including all subsequent amendments thereto, and replace them with the new municipal planning strategy and the municipal-wide land use bylaw, both dated July the 14th, 2026, as presented, and I so move.
And is there a seconder for the motion? Seconded by Councillor Burns. All those in favor signify by, sorry, yes. Is there discussion on the motion?
Yes, I just want to be clear on what would happen if it did get sent back. What is actually going to be reconsidered? Which pieces?
If I may, and then others can either say yes, that's what I heard. I would say it's based on what Counselor Smith has asked for, that review consideration of the, I'll call the proportionality of development on the parcel of land. I think that was your point. And the second would be looking at exemptions or exceptions to the development, on currently existing lots. And what those, that would be, what would be some of those exemptions? Exceptions, okay? Is there any further discussion? So those would be the two things. Anything that planners need to add to that? Okay. Any discussion, further discussion? All those in favor of the motion signify by raising their hands. Those opposed? The opposition are Reinhardt, McLean-Weil, Smith, and DeLong. The motion is carried. That's it. That is the end of our business tonight. The meeting is adjourned. It goes out with a little sputter after all that.